On March 24, 2026, in a Washington state courtroom, defendant Daniel Youssef Sparkman faces arraignment on charges of violating a domestic violence protection order, an order his own mother had obtained against him just weeks earlier. Sparkman, who was already on probation for a prior assault conviction involving the same victim, now stands accused of returning to his mother's property despite being legally barred from coming within 1,000 feet. The case presents a complex intersection of criminal law and mental health, as Sparkman's mother appears in court not to condemn him, but to advocate for treatment over incarceration.
Mr. Sneva, is this your client today?
It is, Your Honor. This time we will be entering a stipulation to probable cause for the purposes of this hearing only. We'll be entering a plea of not guilty. Did go over his rights. We'll waive any formal reading of those and ask to be heard on conditions of release, as well as to be screened for an attorney. He currently is assigned to Mr. Rusnak. There's been no change in his economic circumstance. So I'd ask that this case be assigned to Mr. Rusnak.
Mr. Sneva, were you aware as well that there's an arraignment coming up on a driving while suspended third? Did you?
Did not, Your Honor. Let me.
Yeah, we'll move to dismiss that.
Oh, you're dismissing that matter? All right, we'll dismiss without prejudice the driving while suspended third under 6A18682. And we're going forward. Mr. Sparkman, you've been charged with an allegation of a violation of a protection order, domestic violence, and you're on probation for allegation of assault, domestic violence, and that's what we're talking about today. So accept a plea of not guilty to the allegation of protection order violation. I'm appointing an attorney to represent you, and I'm going to hear from the lawyers here about what I should do as to release conditions, and I'll be setting another court date. So first off, Ms. Kingston.
Your Honor, this is a protection order that was put in place very recently. It stems from an underlying assault case. The alleged victim is his mother. That case just resolved, I believe, late January or early February of this year. The allegations in this case are that he obviously he's not allowed to be within 1,000 feet of his mother's property, and his car was there. And then throughout the day, she saw him walking away from the home on the drive, I think in the driveway away from the home. And then when law enforcement was there taking a report, they saw him walking back until he noticed law enforcement was there. Then he ran off. They were able to catch up to him. There is a lot of mental health concerns, I think, on this matter. That's the main concern of his mother. And because of that, for today, I'm not going to object to a PR. Obviously, we need him to follow that no contact order, but the main concern is the mental health. And so we would ask that the court order a DCR upon release. We have information that he's maybe spoken to his sister from inside and that he's very confused about where he is and why he's there. So based off of that, I would at least be asking for a DCR upon his release. We're not asking for any new orders, just the order that's already in place for him to be reminded to abide by that and no law violation.
Mr. Sneva?
Thank you, Your Honor. I'm not going to object to those conditions. I would note that Mr. Sparkman and I did discuss where a plan for where he can stay, and I don't want to get into the allegations contained here, but he's got a very clear understanding in our conversation of what he can and can't do moving forward. And I think he's at least from my perspective in a good place on that when we spoke.
And did you get any contact information updated?
I did, and that was, let me see, I think that was emailed into the court.
Great, all right, we got that. And someone is in the courtroom on this, and your name?
Yes, my name is Betty Bookheim.
Okay, why don't you come on up to the table there, and then everyone can hear and see you.
Yeah, good.
Right.
Can't hear you either, so.
Yeah,
Good.
so
I'm Daniel's
yeah, I
mother.
figured that out. So you're also the person protected under this order, and there's an allegation that he violated it, and we're setting that for another hearing, and I'm going to set that court date today. And then the other matter that he's on probation for is also going to be heard at the same time, and keep him on probation. And Mr. Rusnak will be his attorney going forward. So any questions?
Well, I understand that.
The prosecution and defense entered a stipulation to probable cause, allowing the arraignment to proceed without a preliminary factual hearing, while the defendant pleaded not guilty and the court addressed release conditions. Under Washington Superior Court Criminal Rule 4.1, arraignment requires the court to inform the defendant of the charges, ensure understanding of constitutional rights, and accept a plea typically not guilty at this stage. The rule permits stipulations to probable cause under CRR 3.2.1, which streamlines process when defense counsel concedes sufficient evidence exists for the charges to stand. Washington's pretrial release framework, governed by CRR 3.2, mandates that courts consider risk to community safety and likelihood of appearance when setting conditions, with personal recognizance, PR release, favored when these factors permit. Here, defense attorney Mr. Sneva stipulated to probable cause for purposes of this hearing only, a strategic concession that preserves Sparkman's right to contest facts at trial while allowing the case to move forward. This procedural efficiency benefits both parties. The prosecution avoids a mini-trial on probable cause, while the defense gains time to investigate and negotiate. The prosecutor's non-objection to PR release, despite domestic violence allegations, reflects the practical reality that Sparkman's underlying issue appears to be untreated mental illness rather than calculated criminal intent. Stipulations to probable cause are common, but carry risk. Defendants waive their right to challenge whether sufficient evidence even supports the charges. For viewers, this illustrates how criminal procedure balances efficiency against rights protection, and how defense strategy often prioritizes future bargaining position over immediate factual disputes.
I have a little input on what I would like to see happen. And I agree with the DCR before he's released, but I also feel it's imperative for him to have a mental health evaluation.
Right, we ordered
Because
that, and I haven't seen that yet. I don't
Yeah.
know his resources.
he has a diagnosis of bipolar schizoaffective disorder, and he has been very dysregulated for a long time. He needs mental health support, and I don't know how to affect that through the courts, but even in my opinion, having known him all my life, his life, he can't navigate this alone. He needs an advocate of some sort to help him through this. And I don't know what you know about mental health or bipolar, but it affects frontal lobe, which is executive management. He's got a lot of other issues going on and is in stress mode
Did he
all the
have
time.
any association with any agency before?
He worked with BHR, Behavioral Health Resources, for 2 years. He was in a program after his first psychotic break, and he did really well. And he was a star. And then his cycle seems to be about every 2 years, he ends up with another episode. The previous one, he got treatment again. He went into Southtown Behavioral Health Hospital, did really well with the treatment, got back on track, got a job. And then about 20 months ago, he started into this next crisis and won't get help, doesn't really feel he needs help. So isn't taking meds, doesn't believe in meds. And I done everything I can, but he's not a criminal. And the way the system works is he's going down that path.
So Mr. Sneva, feel that you had any trouble as to competency today?
I did not.
And
He's not stupid, he's got a mental health issue,
right,
and that's very different.
saying that competency is a whole nother animal. It's not intelligent. It's very fluid and changes potentially from day to day.
So I've heard of other jail alternative programs, and I don't know, I just got a printout for one. I haven't looked into it, but I'm hoping somehow we can set a trajectory to do something like that that's more appropriate for someone with a mental health condition condition rather than, sending him to prison on his third violation.
Well, the issue is, well, the thought is to release him today, is what I'm being heard from the lawyers. And set a court date and have him come back for that. There are no navigators, there are no assistants in the criminal justice other than the attorneys. And so his state of mind is, your experience with this is that,
Well, I think he doesn't have the tools.
yeah,
I support him any way I can, and I definitely don't want to denigrate him, but the truth is I've lived this. I don't know what goes on in his brain, but I know he's very confused and in just high stress mode all the time. That's not gonna lead to good decisions or, and where do you go when you're in stress and you don't know what else to do? You go to your safe place, and that happens to be my home.
yeah. What, you hear something about a sister? Is that realistic?
She lives in Puyallup
Okay,
and doesn't have the facility to,
so it's not realistic.
no,
Okay,
yeah.
all right. Good to know.
The protected victim, Sparkman's mother, addressed the court directly, distinguishing between mental illness and criminal culpability, and advocating for treatment-based alternatives to incarceration. Washington's Domestic Violence Prevention Act, codified in Chapter 26450 RCW, authorizes courts to issue protection orders prohibiting contact and proximity, with violations punishable as gross misdemeanors or felonies, depending on circumstances. Critically, RCW 2650110 permits courts to order respondents to complete domestic violence perpetrator treatment, though this is distinct from mental health treatment for underlying conditions. The Washington State Supreme Court in State v. Ameline 2005 emphasized that sentencing courts must consider mitigating factors including mental health, while State v. Fain 1991 established that untreated mental illness can constitute a mitigating circumstance warranting alternative sanctions. Betty Buchheim's testimony highlights a systemic gap. Her son's cyclical pattern, psychotic break, treatment, stability, medication discontinuation, relapse, demonstrates how criminal courts become default mental health providers. Her explicit distinction between not stupid and mental health issue addresses a common confusion. Competency to stand trial, under RCW 10.77, requires present ability to understand proceedings and assist counsel, which differs from the sanity defense or diminished capacity. The judge's receptivity to jail alternative programs reflects growing recognition, embodied in Washington's Therapeutic Courts Act, Chapter 2.30 RCW, that traditional prosecution may be counterproductive for defendants whose conduct stems from untreated psychiatric conditions. Victims advocating for defendants' release is counterintuitive but increasingly common in mental health-involved cases. This testimony reveals how protection orders designed for safety can criminalize symptoms when no treatment infrastructure exists, raising fundamental questions about whether the justice system should punish or treat behavior driven by psychosis.
So this is what I'm thinking to the lawyers. We're going to set this later this week. I'm going to hold Mr. Sparkman. Maybe there's a release plan that we can put together, a place for him to go, get him hooked up back with BHR while he's in custody, rather than just release him out into the community where he'll victimize or victimize someone else. Potentially be BHR, and but there has to be something better than this, releasing him out there to reoffend. The sister's place is not realistic, apparently.
He did mention he could stay with his dad. That's what I'd heard anyway.
And that he can do. His dad has dementia. I think I don't really know very much about the conditions there, but your surroundings influence your choices. And so there's no support or direction from that.
If we can get, I know.
Yeah, there's another program associated with BHR called PACT, which is an outpatient program. I'll do the research I can do on these jail alternative programs, and I don't know if that's something that's worth looking into for his next hearing?
I'm
And,
hoping the attorneys too will take up the charge and realize that we don't want to just put him out in the community where he's victimizing or victimized himself while he's in this not a good headspace, given a mental health issue that needs to get controlled. Stage, obviously, he can't control it until it's a horrible cycle, I know. So I think we're gonna set this later this week. I'm not sure when Mr. Rusnick has calendars or
His in custody calendars are Wednesday afternoon.
set Wednesday afternoon. 30 calendar. I'm gonna hang on to you, Mr. Sparkman. You're out of compliance on a probation case, so I'm not gonna allow your release. We're gonna be back on Wednesday. I'm hoping maybe the parties can all get together and figure out a better release plan for Mr. Sparkman. And we'll also have a pretrial hearing, probation violation hearing and a pretrial hearing. Get your attorney involved.
Can I please?
So we'll see you Wednesday. I'm not gonna debate it with you, Mr. Sparkman. We'll see you Wednesday afternoon. So that's it for today. We're gonna be back Wednesday afternoon and hope that we have a little bit more information that'll be helpful to,
Okay, because I'm willing to do BHR or a program or something.
that'd be great. Maybe BHR can get involved.
The judge declined immediate release, ordering Sparkman held until Wednesday to develop a structured release plan with mental health services, while coordinating between defense counsel, prosecution, and community providers. Under Washington CRR 3.2c3, courts may impose any condition of release reasonably necessary to assure appearance and community safety, including treatment requirements and third-party custody. The Washington Supreme Court in State v. Smith, 2018, affirmed broad judicial discretion to deny release when less restrictive alternatives are inadequate. For probation violations, RCW 95.210 permits courts to modify conditions or impose confinement when defendants violate terms here. The protection order violation constitutes both new criminal conduct and probation violation, giving the court authority to revoke previously granted release under the out-of-compliance standard. The judge's decision to hold Sparkman pending Wednesday's hearing reflects application of the least restrictive alternative principle from State v. Mulholland, 1993. Release is appropriate only when conditions can reasonably manage risk. By seeking voluntary hospitalization and release, VHR coordination, and PACT program involvement, the court attempts to construct a viable alternative to pretrial detention, recognizing that immediate release without support structure would likely result in further violations. The reference to Sparkman being out of compliance on a probation case triggers the court's broader supervisory authority, allowing detention without bail when probation violations demonstrate inability to abide by court orders. This illustrates therapeutic jurisprudence in practice, using court authority to leverage treatment engagement rather than merely punish. The judge's explicit rejection of release without plan, despite both parties' non-objection, demonstrates how courts can serve as coordinators of fragmented mental health and criminal justice systems, potentially breaking the cycle that Betty Buchheim described. Judge ordered Daniel Sparkman held in custody until Wednesday afternoon, March 27, 2026, when the court will conduct a combined probation violation hearing and pretrial conference. The judge directed all parties, prosecution, defense, and community mental health providers to collaborate on a structured release plan potentially involving BHR services, PACT program enrollment, or VHR placement. Mr. Rusnack was appointed as continuing counsel. No release conditions were set. Sparkman remains detained pending development of viable community-based treatment infrastructure. Betty Buchheim was provided attorney contact information and encouraged to continue researching jail alternative programs for presentation at the Wednesday hearing. This case exemplifies the criminalization of mental illness, a systemic phenomenon where individuals with untreated psychiatric conditions cycle through courts and jails because no robust community treatment infrastructure exists. Washington's mental health courts, established under Chapter 230 RCW, were designed precisely for defendants like Sparkman, those whose criminal conduct stems primarily from unmanaged symptoms rather than criminal intent. Yet access remains limited, and standard criminal courts must improvise solutions. The legal system offers multiple intervention points: competency evaluation, RCW 10.77, insanity defense, RCW 9A 121010, and sentencing mitigation under State v. Fain. But these are reactive, not preventive. The judge's effort to coordinate BHR engagement before release represents recognition that for schizoaffective disorder, incarceration without treatment guarantees recidivism. Viewers should understand that while courts can mandate treatment as a condition of release under CRR 3.2, enforcement depends on community provider capacity, a gap that leaves judges, families, and defendants navigating impossible choices between liberty without support and detention without treatment. If you or someone you know is navigating mental health involvement in the criminal justice system, contact the Washington State National Alliance on Mental Illness, NAMI, at 206-783-9264 or visit namiwa.org for family support resources and information on jail diversion programs. For legal assistance with protection order proceedings, Washington Law Help provides free resources at washingtonlawhelp.org.